And tell me a bit about your background.
So I'm basically a career prosecutor. I worked 28 years at the Clark County District Attorney's Office and enjoyed it, retired. And now I work for Bertoldo Carter, um, Smith and Cullen, and I do, for most part, personal injury work, medical malpractice work, things like that.
Cool. So we were talking a bit earlier about Tupac's case and how you were in the DA's office when it happened. What do you remember from that time?
So the Tupac Shakur case was a big case. As I was in the DA's office, I was a baby DA, just 2 years in the office, and I remember, of course, it blowing up on the news media, and immediately asking everybody that I knew, both in law enforcement and in the DA's office, about where the case was and what was going on the case. And I know that almost immediately at the time, there was a whole back down in regards to the information that was available and who was involved. There was a mad chase to try to determine these things, and for whatever reason, I think we all know probably the reason, the people that were involved were very crammed down on the information, and it was very difficult to go forward with the investigation as I understand it back then. Yeah.
Were you surprised that someone was arrested this year in connection to the murder?
Well, I don't know that I was surprised. I mean, I have seen in my time many cases that basically get prosecuted years after the commission. And, I would note that there's no statute of limitations for murder for a reason. It's one of the most egregious crimes, if not the most egregious crime that could be committed, taking away a person's life, their future, taking them from their family, the potential that they have to the community, all of those things. So, in my view, I'm glad that our DA, amongst all the many other busy cases that he has, certainly would use resources to prosecute a case as significant as this, even after all these years.
So a lot of people are asking why now? Why after 27 years? And some people are saying the reason might be because Dwayne Davis made an agreement with LA prosecutors or LA investigators to basically open up about a bunch of things, including his involvement in Tupac's murder. And he thought he would be immune from prosecution because of this. Do you think that that was on the mind of prosecutors and that's why it took so long to arrest him?
Well, I think that what you're talking about is, I understand, a proffer that was done in California. And a proffer is essentially just a method that a suspect or potential suspect can use to talk directly to a prosecutor or law enforcement without the fear that the statements that he makes are going to be used directly against him. And I think that's what happened in that particular case. Now, it would have been made very clear to him back then that he was given that protection, but that protection was limited in that the information that he was provided could be used by law enforcement to then go on and develop other independent information that could be used against others or even him. And he was also told that if in fact anything that he provided them was false, then all the protections of not using the information against him kind of go away. So I don't know the specifics of the conversation, what evidence was gleaned from that conversation, and how important it is to this case, but all those things I think would come into play and impact as to what extent our local law enforcement could utilize those statements. And I think another issue that they would have to deal with is the fact that it was another law enforcement agency at another location that conducted this proffer and made this agreement. I think that if in fact the DA's office here, the local law enforcement had nothing to do with that, well, I think they would have a good argument that their hands cannot be tied by another jurisdiction. If on the other hand, they might have known about the proffer, maybe even been involved in or received information from it, then I think it becomes a little bit more muddier in regards to whether or not they have the same restrictions placed upon them as laid out in that proffer agreement.
So when a proffer is made, is it just between that person and the agency that's there? So it wouldn't apply to other agencies?
Normally that's the case. However, just from the standpoint of fairness, it wouldn't be fair to a suspect, potential suspect, to go into an agreement with one law enforcement agency while another law enforcement agency sits back knowing that the agreement's been made and says, well, I'm not going to keep that agreement, but I'm going to use all the information from this that I might be able to get. So in that respect, they're clearly, the courts will ferret through the fairness of this. They'll look at the law, and I don't believe there's any real black letter law that's going to say one way or another. I think it's going to be an interpretation, and it's going to be very fact specific. The facts that I'm not aware of currently in regards to how the proffer was made, what was promised, who was involved, those sorts of things.
So could you see the criminal defense side saying what he said was protected, so it can't be used here in court?
So I think that clearly if it's the intent of our local prosecutor to use statements that were made in that proffer, then I think that, yeah, a defense attorney would likely attempt to say, well, you can't use those statements because they were subject to what's called a use immunity, in which they cannot be used against me. And that was my understanding when I made the statements. But like I said, the circumstances as well as the law are going to determine whether or not that argument's going to carry the day.
So prosecution has to be very careful at choosing which evidence wasn't protected in that proffer.
That's completely true. And to tell you the truth, I, as a career prosecutor from the Clark County DA's office, I know the prosecutor involved in this case, and I also know the DA very well, Steve Wolfson, and I'm sure that they have looked at this in detail, and they have done all the math on this, and I feel that they would probably be fairly confident in their position whether or not that they can use this information, or potentially that they have sufficient even information or evidence even short of the information in the proffer to be successful in a prosecution.
Do you think this could lead to a courtroom mess with prosecutors and criminal defense attorneys kind of butting heads?
I think it's very likely probably that this will be an issue in the case. How substantial is the issue? Only the prosecutors involved know that. But like I said, the prosecutor involved in this case is very well versed and has a great deal of experience. So I'm guessing that he's anticipating and is ready for that argument.
And how often do prosecutors or investigators use proffer as a way to get information?
It's used quite often, actually, and there's a lot of reasons to use a proffer. Proffers are used sometimes by individuals who say, well, you know what, I was not involved in this. I was just kind of a victim of circumstance. Looks like I'm guilty, but I want to tell you the whole story, but I don't want to run the risk of saying something that you're going to use against me. So I'm going to give you this proffer. It might be that a suspect or potential suspect will say, well, I'm responsible for something here, but not everything. And so I want to come in and tell you I've got very little culpability here, and I'm willing to take a negotiation for a lesser charge if and give you information as to the person who really did it if you're willing to offer me that lesser charge. So those are sort of normally the reasons why proffers are done.
Cool. Are there a lot of challenges in this case because the murder happened so long ago?
So in cases like this, when things happened a long, long time ago, there always is a trade-off. Because on the one hand, there's physical evidence that was new when it happened, but now it's deteriorated. It's maybe not as useful. Also witnesses. Witnesses remember things in very great detail the closer to the incident. As they get farther out, that gets much more fuzzier. But some of the advantages sometimes to having a case that has waited this long is that technology has continued to change. And sometimes the physical evidence, the technology will be able to use that physical evidence and show it to be much more probative than it was before. And then also, many times, believe it or not, defendants like to talk about their crimes. And in this case, I think that might be the case for Mr. Davis. And those statements can be used later in a prosecution very effectively to show inconsistencies as well as even culpability in a crime.
Because Davis is the accused shot caller, not the person who actually fired the gun, is it possible that the criminal defense attorney for now may ask for a lower bail and say he's not a danger to the community or a flight risk?
Well, I think that the defense attorney will use whatever arguments are available to them, and that might be one of the arguments. I think that if you look at the evidence overall, it would appear that he was as involved as anybody in this case, and clearly he's got every reason to believe, it would appear to me anyway, that he's at great risk. So it would seem that he's a great risk of flight, and that would be a very difficult argument for a defense attorney to make.
All right. Well, James, thank you so much for your time.